Good morning, everybody. It's Thursday, January 22nd. Welcome to the Greater Victoria Real Estate Show. I'm Jane Johnston with the Briar Hill Group, and I'm here with...
Hey, everybody. Andrew Plank here with the Vibe Collective and Royal LePage.
And
Jen Lowe, mortgage broker with Dominion Lending Centers, Modern Mortgage Group, and...
Hi, good morning, everyone. I'm Bhavi Tathgar, and I'm a lawyer at the office of League & Williams.
Awesome.
Excellent.
So Bobby's going to be our guest today. We're going to be talking about wills and estates. And the main question is what happens to your house when you die in BC and how to make it easier. We often get this question from sellers whose children are usually asking, how do we get started? It's a big question. It has lots of nuances here. And Bobby has been a lawyer at League & Williams, and he practices primarily in real estate wills and estates. And he's been a lawyer since 2016. And he's also practiced in the area of criminal law and civil litigation. And you've lived elsewhere in the world, correct?
That is all correct, yes.
Okay.
Awesome. So, Bhavi, someone's in BC here. They've got a home. Let's say they've got family, but maybe they have a will, maybe they don't, but they've passed away. What happens next?
Great question, and this is a very common scenario. So if someone passes away and they own an asset, and it's real estate, and they're the sole owner of that property, in order for that asset to be released to the beneficiaries, the estate will need to commence an application often referred to as probate. And probate will allow that asset to be sold or transferred. Now, just so everyone knows, we've all heard of the term probate, but probate is a court-based procedure. It's used to establish the validity of a will, if one exists, and to appoint personal representatives known as executors. And those executor or tors will have then the authority to act on behalf of the estate. So in a nutshell, probate verifies that the will is the last will of the deceased and it's valid. And keep in mind the validity part. In BC, wills need to meet formal requirements to be valid. A will cannot simply be written on a piece of paper and signed, and that's not valid. So that's why having a properly drafted will is so important for you and your family.
And how do you declare if a will is valid or not?
That is the court procedure of probate. They will be the ones to verify that. There has to be certain requirements. For example, it needs to be signed in the presence of two independent witnesses. There needs to be an attestation clause, needs to be signed at the end. And there has to be certain formalities for it to be valid.
I understand that part of the probate process is to ensure that...
Sorry to cut you off there. If it's not valid, that will can actually be struck down in its entirety.
Jen?
Right. That causes problems. Yeah, Jen, go ahead.
Yeah. So with a property, if you hear of people adding on a child to the title of the home to then avoid that from going through probate, is that correct?
That is correct. So if you add on, say, you're a parent and you're sick, or just for estate planning purposes, if you want to add on a child or children to the title of the property, everyone would have to be a joint owner. So the property would have to be held in joint tenancy, meaning everyone owns it in equal shares. So if the parent or one person passes away, then the survivor would own the property outright, and that asset would not go through probate.
Right. And so that may circumvent the will, the original will, correct?
Absolutely, yes.
Yeah, but I know that's also, I guess it's important, as you said, they have to be joint ownership. They cannot be tenants in common. So if you're on title, maybe you could just explain the difference here quickly, because someone might be saying, well, I'm on title, my mom's on title, therefore if she passes away, it will automatically go into my name. But that's not entirely true, correct?
Correct. So there's generally two ways to own real estate in BC. One is joint tenants, and that means everyone has to be an equal owner. So if there's 5 owners, everyone would own a 20% share. If one person passes away, then the 4 owners would automatically own a 25% share. Then it would go to 33 and a third, 50-50. And finally, the survivor would own the property outright, and this would avoid probate. The second way on owning property is through what's called tenants in common. Now, tenants in common, 2 people can still own the property equally, but if one person passes away, that 50% ownership in the property must go through probate.
Right.
And also in tenants in common, people can own the property as a 1% owner, a 60-40, 70-30, and whatever percentages they like.
Yep. We often see the 1% when some family member maybe want to have some control over a sale in the future. They've lent some money to their child or something, or whatever this case is, but they want to make sure that they have an opportunity to have a say in that property sale without being a full tenant in common or a joint ownership, that is.
I think the purpose is also for them to avoid the property transfer tax.
Yeah.
Janice, yeah.
It's
Okay.
It's an issue. I'm just wondering when somebody passes away, so let's say they pass away in January, what's the timeline for probate from beginning to end? And specifically, are there different areas in the province where somebody can go through probate faster? Because I do know of people who've done that.
Great question. So when I was first practicing as a lawyer in Vancouver, the court time for probate, once you submitted the documents there, it was well over a year. And now in Victoria, it's taking about a month.
Wow.
But the estate application, it ranges. First, the estate or the executors, they must gather information about the deceased and the beneficiaries. And the beneficiaries all must be served, whether someone was named in the will or they were a person that should have been named in the will, like a spouse or a child. Everyone needs to be served. So by the time beginning to the end, right now, probate is taking about, or by the time you start it, by the time we get probate, anywhere from about 6 months to a year, and it depends on the complexity of it as well. And so once the lawyer and the executor prepare the probate documents and we send them to court, the court wait time right now is about a month.
Oh, okay. So it's still a process that's longer than a month.
That's right.
Because there's all the preamble. I do understand that my understanding is that you need to go through and find all of those beneficiaries, because part of the probate process is to make sure that no one is contesting the will. Exactly. And by reaching out to these people and finding them. Yeah. Okay. Yeah.
Do you find that there's disputes for wills now much?
I think there always has been. And our office deals with simple estates all the way to complex estates and wills that are being contested. So I definitely see them. And that's also one of the reasons on why having a properly drafted will is so important.
Mm-hmm.
Is there a bank of wills, a place where like all the wills are stored under your name? I don't know. I heard this somewhere. Is that true?
Yeah. No, it's a great question. So whenever we act for a will maker in our office, we file what's called a wills notice. And this just, the actual will is not filed, but just a record that this will maker named, or who goes by this name, they made a will dated this date, and the original will is kept, for example, in our law office. So that way, once that person passes away, the beneficiaries or the estate is thinking, did my mom or dad have a will? Where is it? Right. So you just have to go online under the vital statistics and you just search for it. And then I think it might take 2 or 3 weeks to come, but it will say where the will is kept.
Assuming it's been registered, because they don't always get registered.
Yes. And filing or having a wills notice is a requirement for probate as well. It's not a requirement to draft a will, but it's a requirement for probate.
Okay. Okay.
Do people get into trouble making their own wills? I know there are will kits and stuff like that, and I'm part of some online chat groups, and I see people saying, "Oh, it's easy," but I'm assuming there's nuances to writing wills. There's a reason why you want to go to a professional such as yourself.
Yes, I deem those will kits or online wills to be dangerous because the will can arguably be one of the most important documents that a person will ever draft in their life, and it talks about your assets and who they're going to. So why take a chance on that? And we have seen will kits or handmade wills being struck out by the court.
And that's, I mean, you're gone, but that's heartbreaking to know, if you could know that all of these plans you had for what you'd like your life earnings and life collection to happen, where it goes to your loved ones or donations or whatever, are no longer valid.
Exactly.
I have lots of questions. I always have lots of questions. I'm just wondering, what are common mistakes that people make when having a will drafted? So, for instance, I was told that if I want to make a donation to a charity, I may want to make it an amount so that amount can be distributed right away, as opposed to a percentage which has to wait till the end of probate, etc.
I wouldn't deem that as a mistake. I mean, whether it's a specific financial bequest or a percentage, they both should be, the executor should wait to distribute those to the charities. I don't know if it's necessarily a mistake, but I know lawyers, when they're drafting wills, we can provide legal advice as to the drafting of a will, and not, for example, notary publics. They might not be in a position to provide legal advice as to the actual will. They might only be able to draft the will, but lawyers are the ones that can provide legal advice as to the will.
Is that maybe not, or they cannot?
They cannot.
They cannot. Interesting. Okay.
Yeah.
When
Jen?
when should someone write a will? Sorry, Jen.
That's okay.
Jane has a lot of questions.
I don't think that there's ever a bad time to draft a will. I've never met a will maker that has said, shoot, I should never have made that will, because wills can always be amended in the future. And if you do make a subsequent will in the future, your previous will is automatically revoked. I would typically say, if you're an adult and you have assets, or your assets are growing, to draft a will. You don't necessarily have to wait until a triggering event. For example, if you have children or you buy a home or multiple homes, to draft a will.
Okay.
If you're named an executor of a will, can you then go out and hire a lawyer to help you with the execution?
You certainly can, yes. And many executors do that as well. Being an executor, it's a pretty overwhelming experience. For example, the first time I ever acted as an executor, I went to the estate home, which was a condo in James Bay, well under 1,000 square feet. And right when I walked in, I could easily notice that there were aisles of floor to ceiling books, and there was a catalog on how many books there were, and the owner of the home stopped keeping track of the books a few years prior. But when I looked in the catalog, there were over 8,000 books. So just to clean out the contents of the condo took about 10 days. And then in this particular case, the will maker was leaving everything solely to a charity, because she didn't have a spouse, but she did have a son, and that son was he was homeless, and he was he had a drug addiction, so she didn't want any funds going to him, and he was also in and out of jail, to be candid. So we actually had to serve him in jail. And so that was my first time I acted as an executor. So it was a lot of work, a lot of stress, and it was quite time consuming.
Wow.
Do you find that the presence of a will maybe solves, or does it create issues within a family or the family members?
Good question.
That is a great question. So to me, I think it's quite clear that having a will would provide clarity to the beneficiaries or to the family. So also, if a person passes away without a will, they are deemed to have passed away on what's referred to as passing away intestate, meaning they didn't have a will, and the court procedure is called letters of administration. If a person passes away with a will, they are deemed to have passed away testate, meaning they had a will, and the court procedure is called grant to probate. We just use grant to probate because it's a term that, it's pretty well known. But for letters of administration, so when a person passes away without a will, it's generally a little more complex. It takes a little more time. And the reason why I don't think it's clear is because all the assets of the deceased, they must pass through legislation. And there's a table in legislation where the assets must go towards. And the legislation is the Wills, Estates, Succession Act, also known as WESA. So if you pass away without a will, whatever you've earned in life, it has to go through legislation, through a legislative table.
Yeah. I think to Jane's question, and I think, if whether you have a will or not, having a will makes everything a lot more clear. Talking to your family about your will makes sure that when you do pass away, that everyone's already clear on your instructions. And if they had some issue with it, maybe there was an opportunity for them to work it out or talk it through beforehand. But at least there's some evidence of the intentions being shared with the family, because there's nothing worse than, I guess, even the family getting blindsided with a will that doesn't match what their expectation or understanding was. That's the kind of will that gets contested, right?
That's right.
I have another question. I'm just wondering, I'm just thinking for my own family, my kids aren't yet really financially literate. Is it okay to have a kind of prerequisite that before they get the money, they have to take financial literacy courses or something, just so that when they get the money, they actually are, well versed in how to handle money so they don't waste it?
That is a great question, and I get that more often than not now. It would be quite tough to put a financial literacy course in there as a prerequisite, because your children, being candid, they might not follow it, or something may happen in the future where they just need the money before. So if your children are not too financially literate, what I would advise is have the age of majority on when they can have assets either staggered or at a later age. They have to be 19 years of age in order to receive X amount from the will. But people they're picking later ages, for example, 25, or they're staggering it, saying, I want my child to have 50% on my estate at age 25 and the last remaining 50 at age 30.
Mm-hmm.
Yeah.
Was that a trust, or is that something different?
Sorry?
Is that a trust?
Yes, it is.
Okay.
And so I was just wondering about that, because you can establish a specific trust and you can have an advisor, right?
You can, yes.
Do you recommend that person be a financial person?
I do. So right now, I'm an executor for this one estate where there's two daughters that are very young. So what I've done is just taken that money, I've gone to a financial institution, and I've opened up a GIC. So it's very conservative, the money's protected, and a financial advisor will just be handling that.
Okay.
Jen, did you have something?
Yeah, just what about death taxes? What are those?
Great question. So with death taxes, clients refer to them as death taxes all the time, but they are called probate fees. So when a person passes away, and we are going through the probate application, in order to actually receive the estate grant or grant to probate, probate fees must be payable, and they're generally 1.4% of the entire estate.
So this is why you can possibly transfer ownership or whatever before somebody passes away. That's why people would do it, is because they're trying to avoid that fee, right?
Exactly. And for an easy number, let's say we take a home that's $1 million without a mortgage, clear title. Probate fees on that would be $14,000. So I mean, it's a good chunk of money.
Yeah.
I'd like to go back to something we talked about earlier. It was brought up earlier, and this has always confused me. And I've heard conflicting stuff from notaries and from lawyers. So this is a little bit off topic, but you mentioned that the notary really can't give legal advice. I've had notaries say to me, no, we can. I've had emails that I tend to send out to my clients to say, here's the difference between a notary and a lawyer. A lawyer can give you legal advice, whereas a notary can help you with the paperwork, but they won't give you legal advice. And then I've had notaries say, no, that's not true. We just cannot go to court on your behalf.
Litigation.
Can you speak to that? Is there, because I heard you saying that they shouldn't or shouldn't be giving legal advice.
Yeah, as far as I know, and I could be wrong about this, so I just don't want a whole bunch of notaries showing up to my door here saying what you're saying. But as far as I understand, that notary publics are not in a position to give legal advice. Even for real estate matters, if your deal starts to go a little sideways or you need some representation, as far as I understand, notary publics have to punt out that file to a law firm. Notary publics are more what I refer to as transactionary, where they can do a transactionary real estate refinance, purchase and sale, or a simple will.
Okay.
We're all going to be rushing to our notary public and checking this out. Everybody.
Yes, notary publics, whoever is listening, I could be wrong, but that's how I understand it.
Well, generally speaking, the training of a lawyer in law is going to be much deeper and wider than a notary public.
And generally, from what I understand in Victoria, notary publics aren't either cheaper or they're not cheaper by much.
No,
so
I don't think they are.
So when clients are contacting me and they're shopping around for prices, I always say, yeah, you're more than welcome to shop around for prices. My advice is, it's the same advice I would give friends or family. If you're choosing between a notary or a lawyer, I would always go with a lawyer, to be honest.
Okay. All right. Well, we can go back to topic. I just wanted to touch base on that because that one was, it's always been in the back of my mind. I don't think it's fully settled yet because I haven't had a legal opinion on this other than yours, but you didn't. You didn't double down on it.
I'm just looking to see here. You have to have anyway, this is not the topic of today's.
No, it's not the topic. Let's have another topic another day. Get a notary and a lawyer in and they can duke it out. How are you finding nowadays with the opportunity where a lot of people are choosing MAID? And I would assume it's a good idea for them to bring their lawyer in for some advice before going through that. And again, the estate planning piece and all of that. I'm not sure if it actually plays into any difference for you on your end to a deep degree, but I guess it just means that people are really a lot more thinking about death and taxes and what happens after them, and they have a lot more choice and autonomy in their choices. So maybe is there anything worth talking about on that level?
Yeah, I have had clients that have done MAID, and to be quite honest, I've actually been in a room where a client has done MAID. Now, with MAID, medical assistance in dying, just for clarity,
Thank you.
A person must have mental capacity while they are signing the papers for MAID. And it's the same with a power of attorney and health agreement. you cannot make those documents if you have lost your cognition or your mental capacity. And the same goes with maid.
Yeah. Yeah.
Right. Thank you. Speaking of,
Go ahead.
okay. I had a situation early in my career, and this has to do with power of attorney, but it also would have to do with estate. I had clients that bought a home, it was a condo, and the seller was unavailable, and the sale was being represented by a power of attorney. They signed the sales documents, they signed the contract. But before we got to the closing date and the property was transferred into my client's name, before that could happen, the actual owner passed away. And so presumably there was a will, but now because this property was only in the name of the seller, they had gotten ahead of things and gotten themselves a power of attorney, but it was only in the name of the seller. At that point, our sale was not exactly frustrated because we were lucky enough that the estate said, you can continue, you can move into the property as if you were buying it. You can live there until we close this sale. And that took a year.
Wow.
Which we were really lucky because as I think our audience might or may not know, with this happening and going into an estate situation, if your clients had planned to be moving into that home, they don't necessarily get to do that anymore. Big lesson for me was to ensure that try to get, if there's a hint that the seller is unwell, get all the documents, the transfer documents signed in advance as quickly as you can. But anything you want to speak to on that, or anything we could have done to mitigate that situation? Or
no, it seems like you handled that situation perfectly. So if there is an indication that the seller is going to be passing away, we would have the sale documents signed immediately. And also keep in mind, for a power of attorney and health agreement, so representation agreement, those agreements, they die once the maker dies.
Yeah.
So the estate or the attorney, in accordance to power of attorney, they would not be able to sign those documents. So if a person has passed away and the transfer documents are not signed, it's the estate's obligation to fulfill that contract.
Yep.
And it seems like in your case, they did a great job signing the documents before, and that's the best course, or that's the course that I would recommend as well. But yeah, other than that, it's a state's obligation, and if the seller did not allow the buyer to come in before, then the buyer could simply walk away.
Yeah, but thanks.
I have one last question regarding having an executor. Do you recommend having a family member or having a professional? Because I find there's a lot of wind up time for somebody who's kind of like, now you're the executor, and they're not knowledgeable about the process. It causes a lot of stress. So do you recommend having a professional? And if so, what's the cost?
Great question. Yeah, great question on that. I would say I don't mind will makers choosing their family, and if they do choose their family, I typically say they should be in close proximity. I've had will makers say, look, my son lives in New Zealand or the States or something like that, and I'm going to name him as an executor. I would steer clear of that. I would also advise the will maker to pick someone that is financially astute and that can handle a certain degree of stress. And they would have to have some financial background or knowledge there. If they don't have anyone, that is where I would tell the will maker, look, I'm happy to nominate myself. I'm probably named as an executor in well over 100 wills. So you're welcome to pick me, but you certainly don't have to. Now, in terms of the charge, in accordance to the Trustee Act of BC, whether it's a lawyer or an individual acting, they can charge up to 5% of the value of the estate. Now, the times that when I have been the executor, like the first time, even I went to that condo and there was over $8,000, I still didn't charge 5%. My personal opinion, I think 5% is a little rich, but you would have to look at the complexity of the will of the estate as well.
Okay, interesting. All right, any other questions, you guys?
No,
Lots, but I'm
I
good.
want. I think the title of this show was, about wills and estates and dying and how to make it easier. And I just want to, say it's not easy. It's not easy and it's a complicated situation. So get ahead of it if you can, and talk to your loved ones. And even Bhavi, we just talked about. I was executor for my mom's estate. It was a surprise to me just how hard that is, especially when it's an emotional time. Plus, and you're digging into a lot of different elements of your loved one's life as you're trying to deal with their financial situation, and it's really hard. So I think that there are times where people are surprised with. They find out they're the executor. I think you don't necessarily need to tell people that they're named to the executor, do you? So that's another piece, is make sure that they're ready and willing and able to be the executor. There's nothing worse than being named. You don't have to, you could be named and say, no, I don't want to do it. But I guess, I don't know if I had a question there. It's more, but if you have anything to comment on that last comment before we go.
No, it was a great comment. And I have had clients that have delayed making a will for a really long time because they're like, I just haven't got around to asking my children. You can put them down and they have the ability to relinquish their executorship if they want to.
Right.
Yeah. Also, just from my personal experience, it puts a lot of pressure when you have a family for one person to be the executor and the other are relying on that person. I think this time around for us, we're actually having a professional do it, and it's just easier because we're all informed at the same time, and we can all chat. Andrew?
That just brings up, I have in recent times dealt with some estate where there's multiple siblings that are named executors, they're co-executors, and they don't actually get along. And that causes problems as well for moving things forward. So it's a lot to consider. You might be wanting to be fair to all of your children by naming them all as executor. You can be co-executor or what have you. But it's sometimes best to have one person in the driver's seat, one person responsible, and let your instructions and wishes be known in advance.
Yeah, agreed. Okay, Bhavi, thank you so much for coming. How do people get in touch with you?
Great question. So they can call my office. Simply Google us at leaguelaw.com. My office number is 250-888-0002. And my email is on my website as well. So feel free to send me an email anytime.
Okay, awesome. Thank you so much for joining us today. I really appreciate it.
Thanks, everyone.
Thanks, Bhavi.
Okay, take care. Bye-bye.
Bye now.
All right, Jen, we're going to get to what's happening in the financing report. Take it away.
All right. So our Canadian inflation ticked up to 2.4% in December. This is mainly due to temporary tax effects, which was not renewed inflation pressure. More importantly, the core inflation measures tracked by the Bank of Canada does continue to cool, which is reinforcing the expectation that interest rates will remain on hold for now.
Okay. Interesting.
Yes.
On hold. Okay. That's every week we wait with bated breath to hear, is it going to still be on hold? Is there some movement? But that's the gist of it. Thank you.
When's the next announcement?
Next Wednesday. Yeah, January 28th.
All right. We'll look forward to that. Okay, Andrew, let's do the stats. Tell us what's
Sure
happening.
thing. Oh, yeah. Well, 304 properties went live this week. So 304 new offerings for all of those buyers to pounce on. That's versus 264 the week before. And we are expecting this to escalate and, speed up a little bit as we go into spring. So we'll see more and more listings per week, I would expect. Same with the properties going pending. As we have more listings coming, we'll have more properties going pending. And that's what we're seeing as well. 96 went pending in the last week versus 67 the week before. Price decreases are down a little bit, only 60 versus 69 the week before. That, we want to see if that's a trend, but that's actually a good sign because that tells us that less people are needing to decrease their price in order to make a sale happen. Jane?
Well, it could also be that people are relisting, they're rejuvenating their listing for the new year. So maybe they're either doing a price reduction or they're relisting. And that explains why the expireds are 65.
65 properties expired, 49 expired the week before. So yeah, when we see 65 expired, you want to take that 65, look over on the right column, look over the left column at 304 new listings. And you want to think about how many of those new listings, 304, could be some of those expireds that have been relisted. And probably, 55 of those.
Yeah, we can look at that. We can look that up for people too, right?
Okay.
And list to sale ratio was 25.34%. That's down from last week at 48.57. So there you go. Wow. Okay, so far this year we've had, is this updated?
It is.
155 net unconditional sales so far for the third week of January. So that's compared to the whole month of January at 422 for January 2025. We've had 600, sorry, I can't read that. What's up?
600 new listings versus 1,172 for the same month last year.
And our total active listings are 2,468. So we're creeping up. We're up net to about 70 from last week, 72. Yeah. So not doing too bad. Yep.
Okay. So there you go.
All right, you guys, if you've liked our show, please like it. Don't forget to subscribe. We are on YouTube at the Greater Victoria Real Estate Show. We are also on Instagram. Please comment. We'd love to hear what you have to say and share. You can watch Andrew, Jen, and myself with our little clips and showing how informed we are. Andrew, how do people reach you?
If you want to reach me, you can reach me at 250-360-6106. If you've been listening to the show and have questions, don't be afraid to reach out with a question. I'm at info@andrewplank.com for email, and you can check out the website, andrewplank.com, or realvibe.ca for the team, the Vibe Collective team.
Awesome. Jen?
You can reach me on my cell, 250-217-4925. Email is jen@jenlowe.ca, and my website is jenlowe.ca.
Okay, and you can reach me at thebriarhillgroup.com. My number is 250-744-0775. My email is jane@briarhillgroup.com. And you can see all of our listings at briarhillgroup.com, as well as you can check out our lifestyle at realtyteacher_remax_Victoria. All right, so we are on every Thursday at 9:30, and we'll be coming to you next week. See you later.
See you later, folks. Thanks, everybody.
Bye.
Have a great